Hello, lovely viewers. Good afternoon to you all. Good evening and good morning, wherever you're watching us from. Child custody or custody of a child when parents divorce only implies as to who the child will physically reside with, even as the mother is the preferred custodial parent when the child is of a tender age. Once the child attains a discernible age, his or her wishes will be considered while deciding the issue of custody and access. Our able lawyer, Kwabena Boateng from Ghana, will take you through all you need to know about child custody rights when we return. Enjoy this very short clip, and please don't forget to like and share our videos and page.
When parents get on well together, their children do better. But we know it can be hard for couples to keep their relationships happy and healthy. Around 1 in 5 married or cohabiting couples are in relationships classified as distressed. That means they argue a lot, regularly consider separating, or regret being in their relationship. Conflict between parents can be easily triggered, often by common things that upset them in daily life. This can be problems with money, or at work, or because of ill health. And around half of all couples say their relationships become strained after the arrival of a new baby. But it can be easy to forget that when relationships are strained, it is children who suffer the most. Children exposed to frequent conflict are at greater risk of depression and anxiety, and are more prone to problems with their physical health. They're also more likely to develop behaviour problems and to do worse at school. And this can have a knock-on effect later in life on an adult's relationships, employment, and their psychological well-being. And that's quite apart from the cost to society. Family breakdown has been estimated to account for £47 billion worth of public spending every year. But this is a problem we have the means to address.
Welcome back, lovely viewers. As I said earlier, we are discussing child custody after divorce. And I said earlier, even as the mother is a preferred custodial parent, when the child is of tender age, once the child attains a discernible age, his or her wishes will always be considered while deciding the issue of custody and access. And with me today to discuss is our able lawyer, Kwabena Boateng from Ghana, and he's going to take you through all you need to know about child custody rights when we return. Yeah. Is our lawyer there? I think he's not there. Okay. So, as I said earlier, divorce is not anything that people prefer. Nobody wants to go through divorce, and after divorce, there are a lot of decisions to be made. Whether we like it or not, there are a lot of decisions to be made. And once the couple are divorced, there's nothing they can do about their life afterwards, especially if children are involved. They have to separate. The children have to either live with the man or the woman. And if an amicable solution is not reached, definitely we have to seek legal counsel. So that's why we have our lawyer today. And he's going to take you through all you need to know about child maintenance, alimony, and everything. Okay, welcome back, our able lawyer.
Sorry,
yeah, I think we lost you.
had some network challenges from my end, but we hope to have a great show regardless.
Thank you very much. I try to fill in for you while you were away. Okay, sir. So welcome back to Family Law and African Retrospect. Many people have been enjoying, many of our viewers have been enjoying this show, and I know they'll continue to enjoy today's segment as well. So please, tell us all you need to know about child custody and custody rights, alimony, and whatever you call it. You know the legal terms better.
Very well. Yes, so today we intend to look at some consequential matters after the divorce process. I hope I'm heard loudly.
Yes, you are loud and clear, sir. Yes, we can hear you. Yes, please go ahead. Go ahead. This network issue. Hopefully, we are going to have an interesting conversation. Hopefully, MT and Ghana. God help us. So we'll be talking about what child custody is all about, and the difference between partial custody and full custody, and sole custody, whatever they call it. So SOLE, not SOUL, and why one parent is sometimes awarded sole custody of a child after divorce. I believe that they take certain issues into consideration, especially if the man is incapable of taking care of the kids, and sometimes if the child is a minor, he cannot take care of himself, bathe, brush his teeth, walk to school alone. So I don't know much about.
When parents get on well together, their children do better. But we know it can be hard for couples to keep their relationships happy and healthy. Around 1 in 5 married or cohabiting couples are in relationships classified as distressed. That means they argue a lot, regularly consider separating, or regret being in their relationship. Conflict between parents can be easily triggered, often by common things that upset people in daily life. This can be problems with money, or at work, or because of ill health. And around half of all couples say their relationships become strained after the arrival of a new baby. But it can be easy to forget that when relationships are strained, it is children who suffer the most. Children exposed to frequent conflict are at greater risk of depression and anxiety, and are more prone to problems with their physical health. They're also more likely to develop behaviour problems and to do worse at school. And this can have a knock-on effect later in life on an adult's relationships, employment, and their psychological well-being. And that's quite apart from the cost to society. Family breakdown has been estimated to account for £47 billion worth of public spending every year. But this is a problem we have the means to address.
So sorry about the network issue with our lawyer, but we'll try our best to get him back. Okay, I think he's back.
Sorry, I've had to switch on to another device. So that we may have to.
Hopefully we are going to have an interesting conversation. So please, sir, go ahead. Yeah, we would like to know, everything about divorce and child custody and maintenance of children. So please go ahead.
Okay. So as I rightly indicated, we have looked at the whole concept of divorce legally. And then we have also looked at the divorce process, how it goes through. Now, after the court declares parties to be duly divorced, there are some other consequential matters that follows. Some of them which the court would necessarily have to attend to, because they are closely connected with the whole process. And the court would have to look at them so that the parties can have their respective rights and go their way peacefully. And also so that some other, in law, we say issues of the marriage, lay people will say children of the marriage, who would necessarily not be part of the divorce process, can also have their rights as children, even as the parties themselves also decide to go their separate ways. So this will give rise to consequential orders such as custody of the children. When we say custody, what we mean is that who should the children stay with? Because we assume that when people marry, they cohabit together, and so their children also live with them. So that upon divorce, the parties, we also assume that people do not live together after divorce. Except I may be pointed to one. I have never seen people who are divorced and still cohabiting. So on this legitimate assumption, the court would also have to look at who should the children, stay with, who should have the immediate, care of the body of these children. Quite apart from that, we are also looking at who is liable to pay for the maintenance of the children. Who the children live with is quite different from who is maintaining the children. So in this respect, we are talking about who is paying financially, who is providing for the care of the children. So that is maintenance. So custody and maintenance, they go together. Then, okay, so these are things that are in respect of the children. Quite apart from the children, we have some other consequential matters which the court, if invited, would look at. And these are matters regarding alimony, as you rightly stated. This is what we call push-off money. Who is supposed to compensate who upon divorce? Quite apart from alimony, we are also looking at matters regarding property sharing. The properties that the parties made during the subsistence of the marriage. How is it shared, as between the parties now that they are parting ways? We also have something we call property settlement. So when we get there, we will look at these things individually. But for today, we are looking at child custody and also child maintenance. Let me begin with child custody. So I have already explained what the concept means. Upon divorce, where are the children going? We assume that the parties are going their separate ways. Now, where would the children also head to? I have reiterated on this program that marriage being a legal concept, the court also recognizes its consequence on society. So two adults decide to cohabit, in this, I don't know how to call it, but whenever I say it, I get problem with religious people. I have always said that marriage is more legal than religious. Yes, it is more legal than religious. What we do at the church, the flamboyance of it, the pageantry of it is what we usually look at. But we also lose focus of the fact that immediately you decide to marry, you are entering into a legal relationship, which also imposes legal responsibilities. One of these things are children. The law places an obligation on parents to be responsible for their children. Now, the word used in the Children's Act is parents. So it is regardless of the fact of marriage or otherwise. So whether the two of you are married or you have decided to part ways, the obligation on you relative to the children still holds. And these obligations are legally binding. So that if the two of you decide not to marry again, that will not affect the issues of the marriage. And going forward, when I say issues of the marriage, I mean children of the marriage. They must be taken care of. They must be maintained. They must be sheltered. Now, when it comes to the children in Ghana, the Parent Act is the constitution. Flowing from the constitution, we have a statute, which is the Children's Act, which takes care of matters regarding children. Now, as I rightly indicated, if you go to Section 5 of the Children's Act, there's an obligation that children cohabit with their parents. Children must grow up with their parents. That is what the law says. Children must necessarily grow up with their parents. There are some exceptions. These exceptions, would go on to say that if the well-being of the child will be prejudiced, or living with the parent will not necessarily ensure the welfare of the child, then the court may go ahead and then deviate from these, position. The Children's Act also says that in taking decisions regarding children, the threshold, the principle that must bind all of us is to look at the best interest of the child. So whenever the court sits to decide anything that has to do with the children, there's only one guiding principle, one supreme guiding principle. That is what is in the best interest of the child. Now, in Section 5, it construes that one principle that will ensure the best interest of the child is for the child to live with the parents, whether they are married or not. And that is why when the parties are divorcing, we want to determine between the two parents which of them should have custody. Because if parents are divorcing, it doesn't mean that we will take the children to children's home, or that a grandparent from somewhere should come and take custody of the child. The law is saying that children must be with their parents. And so if they are going pathways, we must decide where their interest would best be secured. And so it is upon that basis that today we are going to look at what the courts will consider before granting, custody one way or the other. But let us be minded of the principle, as I have rightly indicated, that it is better, the law presumes that it is better that children are with their parents. Now, there is also a provision. I will not bother you with the sections, but the Children's Act also admits that it is best that young children will live with their mothers. So already there is some preferential, preference.
But I have a question.
Yes, I'll
regarding that. What if the mother is not ready to take care or to live with that child or her child?
That is why that presumption that children are better with their mothers is rebuttable. It is not a conclusive presumption. It is not an absolute presumption. It is rebuttable. Rebuttable means that the person who is not in agreement can deduce evidence to show otherwise. So the law presumes that as mothers, generally known, have the best care of their children as compared to men. Mothers are more sedentary, they do not move too far from where their children or families are. Men can go very far, even to the end of the world, all in the name of business and making livelihoods. But we believe that women are more, localized. They move around where their children and families are. So it is based on this societal presumption that we have hinged this presumption of law. But as I've said, it is absolutely rebuttable. The law also recognizes that there are mothers who are into drugs, there are mothers who are alcoholics, there are mothers who are chronic, abusive people. We also know that. So that if the evidence is like that, the mother in question happens to, be this type of mothers that the welfare of the children cannot be secured with, then we may have to, move to the next option, which is, the other parent or any other person who is capable of taking care of the child.
I call such mothers premature mothers. They would rather go to the nightclubs and leave their babies at home.
Exactly.
Oh yeah.
Exactly. And so we should not take this principle hook, line, and sinker, as I have said. For purposes of education, I would like to reiterate that the presumption that children are best, their interest is best secure with their mothers is rebuttable. So that if you know any mother who, is not a mother properly so-called, then the court will have to, step in and then look at the other option. So we have indicated same. Let me also say that in Ghana, the Children's Act defines children to be children less than 18 years. I know that in other jurisdictions, the definition of children would quite differ. But in Ghana, we are talking about people less than 18 years. I know that in respect of other areas, other civil areas, the definition of child also differs. When it comes to contract, we may be looking at 21 years. When it comes to marriage in Ghana, you cannot marry unless you are 18 years. So when it comes to marriage, it is also 18 years. But mind you, the law allows a person to have sexual intercourse when that person is 16. So upon attainment of 16, one can decide to have a sexual relationship. But the law will not allow you to marry until you are 18. I do not know why the law creates that 2 years interval. I don't know the jurisprudential and underpinnings. I don't know if it is to maybe create a period for a lecturer of mine said it's a period for training. I do not know if I'm competent to comment on that, but that is the law. You can have sexual relationship at 16, but you should wait till you are 18 to get married. Even from the 18, the law is saying that until you are 21, though you are mandated to get married, but if you are not 21 yet, you would need a next friend who would file an affidavit and sort of endorse or speak to your competence physically and morally to enter into that marriage. But of course, the general law is that from 18 you can get married. So our definition of a child is 18 years per the Children's Act. Section 5 of the Children's Act is saying that children are best off with their parents. The same law is saying that yes, children are best off with their parents, but they are more better off with their mothers, which I've said that is rebuttable if the situation demands so. Now, Section 6 of the Children's Act places an obligation on parents, married or otherwise, to ensure the welfare of their children, including shelter, including food, clothing, and education. The law construes education to mean basic education. So it uses the word the necessaries of life, which is quite wide. So anything that goes into the necessaries of life, such as I've mentioned, food, shelter, security, clothing, education, and all that goes into the necessaries of life is the obligation of the parents. And the law says whether they are married or not.
Okay, sir, please, before you move to maintenance, somebody has a question. The person is asking if there is anything like partial custody and full custody. If you can explain, is there anything like partial custody and full custody, or sole
in Ghana,
custody?
What we have is absolute custody and then right of access.
Right of access, absolute
right
custody.
Of access. Yes.
Okay.
So the court will grant custody to one person and will grant access to the other.
Okay.
So that the court can say that the children should live with their mother and grant access for the father to visit. So the access can be in the form of a visit or some days off with the father or mother, whichever way it is. So the person that has the absolute custody is who the children are staying with.
Okay.
Whilst the other person may be given some time to be able to visit the children.
Okay.
Or take the children off to his habitation for some time. So the court will make specific orders, regarding this. So I'm sure that is what your viewer means by partial custody.
Yeah.
In Ghana, we call it access.
Yeah, he's also asking that why is one parent usually awarded that absolute custody? Is there any reason
basis for determining?
Do they consider? Yeah, do they consider anything before?
Yes, they do. Some of which I have mentioned. The first one are these two presumptions of law, which I have mentioned per section 5.
As mentioned earlier.
Yes, as mentioned earlier. These are, the threshold, the grounds based on which the court will decide. Mind you, the court does not grant custody to only parents, except that it gives preference to parents. But if the circumstances demand, the court may grant custody to some other persons, even including children's home or foster, care parents. So let us progress in that order. I'm sure by the time we are done, the understanding would be clear.
Yes, the understanding will be clear. Yeah, you're right.
Yes. So to answer the question appropriately, there are grounds that the court will consider. The first one is that children are best with their parents. The second is that children are best with their mothers. Okay. So these are the two grounds upon which the court would look at. The next step
Another
would be
person
that
has a question. Yeah. Okay. She's asking she's asking that can parents reach an agreement before the court makes the ruling?
Of course. In all circumstances, the court entertains, mutual agreement. These are what we call terms of settlement. We file it every day in court. It happens very often, even in extreme, very contested litigations. Immediately, the parties are able to agree to form consensus. The court is happy because you spare the court, time to legally determine their respective rights and all that. So when the parties have agreed, yes, the court would look at their agreement and then see if it's in the best interest of the child. Because I've indicated that is the overriding principle. The guiding principle is not what the parties have agreed on, but it is what the court deems to be the best interest of the child. So if what the parties agree on is in the best interest of the child, the court will adopt same and cause their circumstances to toe that line.
Okay. Thank you. I think it's understood. Yeah. Please proceed.
Yes. So we have looked at how the courts would determine custody. Now let me come to access. Section 44 talks about access. It says a parent, family member, or any person who has been caring for a child may apply for periodic access to the child. So who can apply for access to a child is any other person other than the person who has immediate custody. Because if you have immediate custody, you don't need access because the children are with you. So any other person who was not given the immediate custody may apply for access to be able to visit the child or take the child away for some time. Now, the subsection is talking about grounds that the court will look at when granting these access. And it says that the age of the child is very important when granting these access. And it is also saying that in the subsection B, it's saying it is preferable for a child to be with his parents, except if his rights are persistently being abused by the parents. The C is saying that the views of the child would also be taken into consideration when granting both access and custody. So what I'm saying applies both to access and custody. The court may also find out from the child. That is if the child is capable of preferring an opinion. So we are talking about children who, maybe 8 years, 9 years, 10 years. They can prefer an opinion. They can show a preference. That is not to say that the preference of the child is absolute. I've said that the court will have to determine if indeed it's in the best interest of the child. The child may look at, some factors to say that I want to be with my father, considering a father who may not necessarily be seeking the interest of his children, but may subject the child to, some extreme pampering and, lifestyle, which in the view of the child may be in his or her interest. For instance, if, you take a child out of school and, he has the whole day to sleep, the child will not have to do his homework. He's eating candies all the time. To the child, this is heaven.
Yeah.
No stress, no homework, no bedtime, video game 24/7. To the child, that is his best interest. But the court would look at it the other way around and say that no, this is not the best interest. So the law allows that the child also professes some preference, but it is subject to what the court deems to be the best interest of the child. The next point in also granting this access and custody, we are making them to look at the grounds. It's also that it is desirable to keep siblings together. This is in section 45. It's saying that the court in granting custody and access should take into consideration the fact that children are better off when they stay with their siblings. So if we are talking about 5 children of the marriage, should the court, in the name of equity and fairness, say that I'm granting 2 of the children to the mother and granting 5 to the father, granting 3 to the father, or to say that if the children are 4, ordinarily the fair thing to do is to share the children among the parents, since equity is equality. You take 2, the other take 2. That is fairness, ordinarily. But the law is saying that it is better that children live with their siblings. These will necessitate that the court grant all of them to a parent. It may seem unfair on the face of it. At least the other party can also have, 2 or even 1 as consolation. But the law is saying that let them live together. They grow better, they socialize better, they become better adults when they grow up with their siblings. So it should not surprise anybody if the court grants all the children, custody of all the children, to a parent. That is also a presumption of law. It is a presumption of law that they will be better off if they grew together with their siblings. So the court is also supposed to look at that. The next one
I think it's logical.
Yes.
It's very logical. Yeah.
It is. It is. I think we have seen a lot of effects on children growing up when their siblings are elsewhere and they are also elsewhere.
Yeah. There will be no love,
yes.
No
exactly.
love, no unity.
Exactly. And also considering the fact that the child in question may have lived with his siblings for so long until the time of the divorce. So that abrupt separation is something that the law considers to have effect on the child. If children are separated right from their childhood, let's say from birth, the effect may not be so much. But they have been with their parents, they have lived together until, maybe age 10, when their parents decide to divorce. And then all of a sudden, 2 of his siblings will have to go the other way, and then the other remain. The child cannot understand. It may not be able to live with that sudden, separation between where he is and the other siblings would have to be at the other side. So because of these, the law says that the children it's good that they remain, together. The next point is also the need for continuity in the care and control of the child. The need for continuity. This continuity would, bring a discussion of who had the care of the child immediately before the divorce. So if, immediately before the divorce, the children were with their father, then the court may look at that and say that, well, for purposes of continuity, the children should continue to be with their father. We are saying this on presumption that a lot of time before the divorce happens, there is separation. The divorce is always preceded by separation, where the parties may have left their matrimonial homes and cohabiting in their respective habitations. So the mother may have left, the children are with the father. Now, a formal divorce is filed in court. Custody of these children have to be determined by the court. The law is saying that the judge should look at continuity, the need for continuity in the care of the children. So, assuming the children already by default were with their mothers, the mother may have found a school for them where she stays. The children may have built societal connections with where the mother stays. So it is good that that continuity happens, so that the children are not abruptly uprooted from where they have gained some recognition, where they have gained some societal connections, and where they may even be schooling. It may prejudice their well-being if they are immediately uprooted and then planted elsewhere to begin a whole new life again. So we are mandated to look at continuity, which would automatically place a preference on who had the immediate care of the children immediately before the petition.
Yeah.
So the last point is the law says any other matter that the family tribunal may consider relevant. So this is an omnibus, clause, which gives the family tribunal, which in Ghana is the district court, sitting with the Department of Social Welfare. They constitute the family tribunal here in Ghana. The court says that they can look at any other relevant matter in determining who should have custody. So let me run through these things. First one is the age of the child. How old is the child? If the child is very young, then the law says it is better that a young child will be with the mother, because a man cannot breastfeed. A man may not be able to take care of the very immediate need of a young child. So we should look at the age. That's one. Two is that it is preferable that they live with their parents. That is the second point, which we have explained. Three is that the court should take into consideration the views of the child. If the child can give an independent views, the court may pay attention to it, but that is not binding on the court. Yes. And then also the fact that it is desirable that the children live together, siblings live together. That is also one ground that the court should consider. And then continuity in the care and control of the children. And then the last one is the discretion of the family tribunal to look at all other circumstances which may influence the well-being of the child in deciding to grant custody or access one way or the other. So these are the grounds. Now let's go to section 46, which is very important. It creates an offense. Section 46 creates an offense, and that offense is once the court grants custody to one person or the other, it will be unlawful for any other person to forcibly remove the children from the custody of that person. So if the court says that the children should go to their father, it will be unlawful for the mother, one Monday afternoon to go to the school of the children and grab them.
The children.
Or a Sunday morning to meet the children at where they attend church and grab them away. You can't do that. When the court grants the custody, any person who forcibly removes the child from where the custody has been granted commits an offense. Yes. We have seen such instances. Some of the parents will go to the school.
So many.
So you'll be waiting for the child to return from school. The child will never return.
The child will never return.
Yes, and you will find the child, elsewhere. If you do that, you are committing an offense, which is punishable. So it is very important that for purposes of education, we will reiterate that point. Because of our time, quickly let's look at maintenance.
Maintenance, it's very important.
Yes. Yes. So maintenance is who is paying. So the law from Section 47 talks about maintenance. It says whoever is legally liable to maintain the child. Whoever is legally liable. So it is in order of hierarchy. The first, the top of the hierarchy are the parents. They have the immediate care of the child. They are supposed to provide the necessities of life for the child. Now, going from there, the parents, as between two of them, may in their individual rights have the capacity to take care of that. They may all be earning. In that circumstances, not so much problem is created. But in other circumstances, one parent may be in a better position to provide than the other. So the court is saying that as long as you are a parent, you have a duty to the child. Secondly, we are looking at who has a deeper pocket. Among the two parents, who is more capable of paying? So usually when the court is making maintenance orders, we take evidence of their respective jobs and earning capacities so that the court can determine how much the respective parents should pay. It is possible for the court to grant maintenance, the monetary aspect of the maintenance, wholly on one party, and then grant some other non-cash maintenance, requirements to the other.
Okay.
So whilst the man may be asked to pay for, the necessities of life, the woman may be asked to do some other things, non-cash or non-monetary, but which also goes into the maintenance of the child. Men tend to think that, when you put the money down, that is all. I've always asked myself this question. When you have put the money down, you see that the money will not walk to the kitchen to cook. You may as well put the money in the pocket of your child and leave the child and come back next week to see if the money that you put in the pocket of the child has cooked food or has bathed the children or provided the necessities of life for the children. Yes. So it is not always about who is providing the money. Most often, the non-cash contribution to the maintenance of the children is very, very, very crucial. Very, very, very crucial. So in doing this, the court would, as I've earlier indicated, look at their respective capacities in terms of earning to see who is more pleased to pay. And then also look at what the other party can also provide by way of a non-monetary contribution. So that is, I don't know if there's any question from that angle.
I have a question. What about men who decline their responsibility? For instance, after a divorce, and if they reach an amicable settlement, that without seeking redress from court, that's okay, let the children be with the woman, and then they decline their responsibility, they don't provide cash or emotional or spiritual support. What about those people?
In fact, let me speak generally from the law. If you fail to care for your child, you are committing a crime.
Okay.
Which you can be imprisoned for. At least I can speak for the Ghanaian jurisdiction. I don't know about elsewhere.
Yeah.
But if you fail to care for your child, it's a crime, which you can be prosecuted. And then anybody that has immediate care of the child can also sue you in the civil realm for those monies. Apart from you facing the criminal sanctions, the Department of Social Welfare can bring an action against you. And any other person that has immediate care of the child can also bring a civil action against you and proceed against your properties for it to be sold to take care of your children.
That is very good.
When we say, yes, when we say care of a child, most often we tend to limit it to monetary care, but it goes beyond that. It goes beyond that. Often, what we see is that people fail to provide monetary care, and so it has become, the seldom, issue that we see, quite often in the police stations.
Yeah, besides that, some also do not provide emotional support. Once they've ended with you and started a new family, that is it. That is the end. Your own children don't have any right. They don't benefit from you financially, emotionally, spiritually. They don't care, even if they are staying in the same country.
Well, if they are not benefiting,
I know so many people, but due to lack of education, I think they don't know the right step to take. So at the end of this conversation, I would like you to give the guidelines, the procedures to be taken, or steps to be taken to seek redress legally.
If a child is not benefiting financially from a parent, as long as that child remains a child, the parent is committing a crime. Let us state that emphatically for purposes of education. It's a very serious matter. It is a crime. It is a crime to have a child in this country and elsewhere. I am confidently to say in all jurisdictions, and not care for the child. It is criminal. What I have seen is that most parents would then say, it doesn't matter, God will take care of his own. And yes, we appreciate that. But the unfortunate aspect is that most of the parents that make such utterances do not have the financial capacity to, take care of the well-being of the child. It is high time that we advise that if you have a child with somebody, that other person has the capacity to take care of the child, but is deliberately neglecting the children, you should make a complaint. Go to any police station.
Not only one child, sometimes 2, 3, 4, 5 children.
Yes. For which reason our streets are inundated with, street children. And these are people who are on their way to be hardened criminals. So anytime we see these people on the streets, let us be minded that we are gradually jeopardizing the security of the country, because there's no two options. The option is just one. They would become hardened criminals. Very few of them, for some miraculous and by some divine intervention, end up being, some responsible members of society.
Yeah, they don't always come out well.
They don't.
Yeah.
They don't. Yes. So it is for these purposes that we have criminalized deliberate neglect of one's child. In fact, it is not only your child. The law says anybody who is within your immediate care. That is why I gave the hierarchy. The top of it is the parent. Down the line, anybody that you have custody of. So if the law places somebody in your custody, be it your child or not, you should maintain that child. You should take care of that child. Neglect to do that is a crime.
Yeah, sir. I think that we have a lot of questions here. Maybe you can take 3 or 4 questions before the end of the show. Sister Annalyn again. Brother Bukai, it's a very educational program. Thank you very much. Hero, he said, watching from Ghana, and I can't stop watching. This program is mega. Thank you, Hero. God bless you, my dear brother. Sister Annalyn, she's asking that can the father take the mother to court for maintenance?
Yes.
Can the man take the woman to court for maintenance?
Yes, the man can take the woman to court for maintenance. You know, usually when we talk about maintenance and let me divert a bit. When we talk about alimony and push-off monies, people tend to think that it is always men paying to women. That is why in the law we use the word parent. So it works both ways. That is why I also said that the benchmark in determining who is to pay, the court will look at their respective pockets and their earning capacities. So if the man is jobless or the man does not earn much and the woman is well-to-do, the court will order maintenance against the woman.
Okay.
Yes, it is the same way as if upon divorce, the court finds out that the man is, impoverished and the woman is, better to do. The court can order the woman to pay alimony to the man. The court can order the woman to compensate the man. So it works.
Even if it was the man's fault that the divorce happened?
Well, the court would look at all those circumstances in determining quantum of compensation. So next week when we get there, we'll discuss the marital part. But yes, okay. To answer the question precisely, a man can take a woman to court for her to maintain her children.
Okay. Thank you very much, sir. And our brother Ebuka, he's also asking, he's from Nigeria, he's asking, how practical are these sanctions in Africa?
There are people in prison for not taking care of their children. I can tell you that on authority. I have had to go to the police station, the Dofsu division of the Ghana Police Service. I have had to go there to get bail for a lot of men who have been arrested and, detained by the officers of the Dofsu failing to take care of their children. So I can tell you that on authority.
Okay.
It works.
Thank you. Thank you very much, sir. And Hero, he says, in the case where the mother dies, can the man who is alive go for the children without the consent of the court? Like after awarding absolute custody to the mother of the children. And if the mother dies, can the man who is alive go directly to take the children without the consent of the court?
Yes, let us say that even when the woman that has the immediate custody is alive, the man still have right of access. So if the woman dies, the next preference in terms of the hierarchy of custody is the man, unless his circumstances is such that the well-being of the children will not be secured with that man. But if the children have the ambience that will augment the well-being of the child, of course, he is next in line when it comes to custody. As against, let me say this. I've seen a lot of situations in Ghana where the woman is no more. The family of the woman take control of the children and prevent the man from seeing his own children, all in the name of Akan, custom that children belong to their maternal side.
Maternal side, yeah. Matrimonial inheritance.
No. You cannot disinherit, you cannot disentitle a man from having access, or if he's so capable and his circumstances is convenient, from taking over his children and taking care of his own children under his own roof. In the absence of the mother, the man is the next preference. In fact, sometimes even in the presence of the mother, the court still awards custody to men. Yes, so let us educate ourselves and begin to depart from that, mindset that in Ghana and in most parts of Ghana, children belong to their matrimonial side. Yes. Yes, and I've seen a lot of grandmothers on the maternal side, misbehaving and taking advantage of this. The children are mine, take over the children and will not even allow the man to know where the children are. That is unlawful. Well, I mean, your parents should know the appropriate forum for redress. If there's any pain at all, there should be an appropriate forum for redress. But you
maybe
not stick to this entitled. Yes, maybe.
Okay, and there's another question. It says, why some women only take care when they are having more than the man? Okay, brother Fortune, he's asking that, but why some women only take care of the children, maybe when they are having more than what the man has? I didn't really understand your question, brother. Okay, he also says that these problems happens when the mother and father are no longer together, which is very bad in our African society. Yeah, it's really bad. That's why the court tries as much as possible to ward off divorce.
I think the other question is trying to say that will the woman only be mandated to pay for the care of the children if she is richer than the man?
Okay. But if he's richer than the man,
that is not the law. The law is saying that two of you are responsible, except that the quantum of your contribution to the care of the children depends on your earning capacity. So if the man earns more than the woman, it doesn't mean the woman will not contribute to the care of the children, except that her portion of contribution will be less than the man.
Okay.
Yes.
Thank you very much, sir. And Sister Diana, it's a good topic for discussion. Thank you so much. We are happy to see you, Sister Diane. God bless you. For full-time bars, it's a blessing, full-timers. God bless you too, sis. Thank you so much for joining us. Okay, sir, I think our time is fast spent, so you can just summarize everything for the benefit of those who joined us late.
Yeah, so today we talked about custody, we talked about maintenance. We said custody is who the children should stay with, maintenance is who should pay for the children. We are saying that the court in granting custody and maintenance will look at some things. One is the age of the child. If they are so young, the court will grant them to their mothers. If they are a bit older and they can stay with their fathers, the court will do same. We also looked at the principle that it is always better that the children live with their siblings. Siblings will be put together so that the court in granting custody will not divide the children. Put two of the children here and put the other set also there. It is good that they live together. The court will also listen to the children. That is, if they are capable of talking and preferring an independent opinion. The court will ask them which of the parents they would prefer to live with. And that opinion by the child is not absolute. The court will look at the well-being and what is in the best interest of the child. We also talked about continuity of the care of the child. If the children are already planted where one of the parents reside and is schooling there and is being taken care of by that parent, has, established friendship and connection in that society, the court may not necessarily be interested in uprooting them into another, society, unless that is in the best interest of the child. So these are things that the court will look at in granting custody and access to the child. When it comes to maintenance, we are saying that under Chapter 5 of the Courts Act, parents are responsible to take care of their children. In fact, it is a crime to have a child and not to take care of the child. And in ordering how much a party should pay, the court will look at their respective earning capacities. So the one who earns more will pay more. The one who earns less would pay less.
Okay, not necessarily the man alone.
Not necessarily the man.
Yeah. Okay, thank you very much, sir. We acknowledge the presence of Sister Inse Samuel Kesali. Good evening. She said good evening to you all. And Young Rich, oh, you've also joined. Thank you very much. It's a good topic. Sister Inse is saying that good point. Children need each other to support one another. You are absolutely right. Children need each other, especially in the absence of one parent. Thank you so much, lovely people, for your lovely contribution. And sir, thank you very much. You've always been a blessing to full-timers and for the free counseling and everything. We are so privileged to have you. Yeah. So thank you. God bless you. And hopefully we will see you next week as we continue this interesting discussions. I cannot wait to see you again. God bless you.
Sure.
And God bless you all. Yeah, have a nice day, sir. God bless.
When parents get on well together, their children do better. But we know it can be hard for couples to keep their relationships happy and healthy. Around 1 in 5 married or cohabiting couples are in relationships classified as distressed. That means they argue a lot, regularly consider separating, or regret being in their relationship. Conflict between parents can be easily triggered, often by common things that upset normal daily life. This can be problems with money, or at work, or because of ill health. And around half of all couples say their relationships become strained after the arrival of a new baby. But it can be easy to forget that when relationships are strained, it is children who suffer the most. Children exposed to frequent conflict are at greater risk of depression and anxiety, and are more prone to problems with their physical health. They're also more likely to develop behaviour problems and to do worse at school. And this can have a knock-on effect later in life on an adult's relationships, employment, and their psychological well-being. And that's quite apart from the cost to society. Family breakdown has been estimated